My name is Shamsah Lalji, and I'm the owner and director of Comfort Care at Home. I'm here today at the lovely Russell-Cooke offices in Kingston upon Thames with Kieran Bowe and Annika, who are both solicitors, and they work with clients with topics such as wills, trusts, powers of attorney. When is a right time to make a will, and is a will legally binding?
So like with lasting powers of attorney, it's always best to consider making a will at any stage of life really. Once you're an adult, and if you have certain assets in your own name, then you should certainly consider putting one in place, even a simple will to cover yourself. In terms of with wills, once you put one in place, it's important to review it. We suggest every 3 to 5 years or so, or if there's certain life events. So marriage revokes a will, so it's always important to seek advice around that time, either on the run up to the marriage, preferably, or once you've got married, seek advice to renew your will at that time, or any other life events such as divorce, having children, or if your assets change at all, it's also a good time to review your will. So if a will has been validly made, so if it's in writing, signed by the individual in front of 2 witnesses who've also signed the document as well, then it will be legally binding and in place for you.
But of course, if you don't have a will in place, then you're reliant upon the intestacy rules. Now, those are rules that provide how your estate would be distributed if you have not taken the time to make a will in your lifetime. Those rules are quite rigid and may not be suitable for everyone. So I think it's very important to remember there is no such thing as a common law spouse. So if you have not made a will, your partner or cohabitee will not benefit from your estate. The rules of succession under intestacy make provision for a spouse and up to a fixed legacy, which will be £322,000. Everything is then split between the spouse as to 1/2 and the remaining 1/2 for your children upon attaining 18 years of age. Now, if your children are receiving a large sum of money at 18, that may not be appropriate. And by making a will, you are taking steps to manage how your loved ones will inherit in the future.
What should I think about when making a will?
So when thinking about making a will, it's about how your estate will pass to who you would like to inherit. So it's thinking about what assets you have and who there is in your life, whether it's family, friends or charities that you would like to benefit and what you would like them to benefit from, whether for example it's a cash legacy, share of the residue or a certain personal item, for example.
I think one of the important things to consider in your will is not only who benefits, but whom you're appointing in terms of who will be your executors, who will carry out your wishes when you have passed. And fundamentally and crucially, one of the most important things you can do in a will is appoint guardians for your children.
And so who should the executor of my will be?
Often the executor can be a spouse or a partner, perhaps your children. But if you don't have persons that are close to you, you can appoint a family friend or a trusted professional such as a solicitor or an accountant to look after your estate and to ensure that your wishes are carried out after you have passed.
So if you have a spouse or a child who is your executor, can they also be in your will as a recipient?
Absolutely. An executor can always be a beneficiary of a will, and that does not present any problems at all for the purposes of administering the estate.
And can an attorney change your will?
Generally speaking, no. A will is made by the person who has prepared the will, the testator. If you have made a lasting power of attorney appointing someone to look after your affairs, they do not have the power under that document to change your will.
This has been very enlightening. Thank you both so much for your time today.
Thank you.
Thank you.